And counsel, your appearance, please.
Attorney Corey Westmoreland appearing on behalf of Mr. Hill. Mr. Hill, would you please state your name for the record?
Brandon Hill.
All right, thank you. Today's the day before the arraignment in this matter based upon your client's arrest, and counsel asks the arraignment.
At this time, Judge, we are prepared to waive the formal reading. My client stands mute.
Or waive the formal reading, enter a plea of not guilty for purpose of the arraignment, schedule this matter for pretrial September 19th at 10:30 a.m. And counsel adds to bond.
Your Honor, I would like you to know that Mr. Hill currently resides in River Rouge. He is currently working as a caregiver for his mother. He's not currently on probation or parole. He does not have any other pending matters out of any other jurisdiction at this time. And after speaking with him this morning, he did assure me that he would be appearing at all future court dates, and he has no history of absconding from any honorable court. I would just ask that all that be taken into account when assessing a bond on behalf of Mr. Hill.
Okay.
This starts out pretty typical. The attorney speaks up. The defendant claims Hill followed the rules, but don't be fooled. Things take a weird turn fast. You'll see what I mean.
So, Mr. Hill, you're not on probation or parole anywhere?
No, I say that proudly.
Okay. And so what happened with your most recent matter out of River Rouge?
What do you mean?
August of 22, it shows traffic offense ordinance violation.
No, here, take this. This guy waived.
And also April 27th of 22.
No, that's is all taken care of.
Okay, I was just asking what had happened with that. And do you have any?
I apologize. I misunderstood you.
You can already feel the tension rising here. The judge is trying to understand Mr. Hill's past record, but the defendant is vague and almost annoyed. That kind of energy in court is never a good idea.
Okay, do you have an issue with standing up, sir?
Yeah, I'm having an issue with standing up right now.
What's that issue?
I wish I can. I don't know. Draws.
Do you have a back issue? Do you have a leg issue, a foot issue? We're not quite sure.
I have a leg issue right now.
Okay, and so is it broken? What's going on?
I'll try to stand up. Okay.
Sir, I'm just trying to figure out. Oh, do you not have pants on?
That's one of the reasons for that.
Oh, okay. You can sit that down, sir. I was just curious. It was unusual for somebody to be sitting down, so that explains that.
This was the most unexpected part of the hearing. He says he can't stand up because he doesn't have pants on. Flush face. The judge tries to stay calm, but you can tell she's stunned. Honestly, this felt more like a prank than a real hearing.
Okay. Have you ever failed to appear in court, sir?
Well, that's obvious, ma'am. Yes, I have.
Why is that obvious?
I'm sure if you have register of actions, you can look at that and see that I had an issue before. But
Have you since
I haven't had an issue. I haven't had an issue since.
Have you since cleared it up, sir?
Pardon?
Have you since taken care of the matters that you failed to appear for?
Yes. Everything's taken care of.
Now, we're talking about failing to appear in court, and instead of just taking responsibility, the answers are vague again. The judge keeps asking questions, but it's like pulling teeth.
Okay. And sir, if you were to test today, what's in your system?
Excuse me? Why is that relevant?
Sir, because the court has to determine bond and bond conditions. And so, given the charges, sir, the court finds that relevant.
Okay. I just asked.
So if you were to test, what would be detected in your system?
Oh, nothing.
And if it was something that was not nothing, what would that something be?
I would say nothing.
And you're a caregiver for your parents?
Yes. Yes.
And do you receive compensation for that, sir?
My spouse does. But I have to relieve her because it's a full-time care.
Wait, I'm sorry. Your spouse
Yes,
is the caregiver and gets paid for that, but you're the caregiver?
we're both the caregiver. They don't give us enough money. They don't give us enough money.
This carer story feels off. First, he says he's a full-time carer. Then he says it's his spouse. Then he says they don't get paid enough. The judge seems skeptical, and honestly, so am I.
Okay. And what is your spouse's name?
Angela DiMaggio.
All right. Based on the nature of the charges, based on the criminal history, the court's going to indicate a $5,000 10% bond. In the event you post bond 3 not to possess or consume any alcohol or drugs unless prescribed, and we'll see you back on September 19th.
Thank you, Your Honor.
500, she said.
Thank you.
Despite everything, the judge sets a $5,000 bond with 10%. That's not small, but she could have been a lot harsher. You can tell she's trying to balance being fair but firm.
Matter of David Minor Reed, 222322.
Good morning, Your Honor. Mr. Shepard, bring me up my client who approaches me stand.
Thank you. And your name, sir?
David Minor Reed.
All right, thank you. Today is the date scheduled for the probation violation. Mr. Minor Reed is on probation for assault and battery, and it's alleged that you tested positive for alcohol on August 8th. And this would be technical violation number 2.
Yes, Your Honor. I've had an opportunity to review the allegations and my client's right to a hearing that will not be necessary. We are ready to proceed.
All right, sir, please raise your right hand. Do you solemnly swear from the testimony about to give this matter the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. And you heard the 3 that your attorney placed on the record, correct?
Yes.
As to the allegation you tested positive for alcohol on August 8th.
In part 2, we meet Mr. Reed, already on probation, now back because he tested positive for alcohol. He pleads guilty, but says he didn't mean to. That excuse, you'll hear it a lot.
How do you plead?
Guilty.
You got over your advice of rights for probation violation purposes, correct?
Yes, Your Honor.
And you understood all of those rights.
Yes, Your Honor.
You also understand the possible penalty as a result of your plea.
Yes, Your Honor.
The recommendations for you to continue complete our terms of probation, revoke under advisement status, pay a $50 probation violation fee, attend outpatient, and 30 days on the alcohol tether.
Yes.
You understand that's only a recommendation. This court does not have to follow that recommendation in full. May only follow it in part or otherwise. Do you understand that?
Yes, Your Honor.
You also understand that by entering into a plea, you'll be waiving your right to having a contested hearing. And despite knowing all that, you still want to continue with your plea.
Yes.
He blames medication, NyQuil, creams, anything he can. The judge is patient, but he's been here before. It's the second violation in 2 weeks.